Good morning and good afternoon to all of our webinar attendees and to our panel for our webinar, GDPR Reality Check, How Will Regulations Impact My E-Commerce Business? This webinar is an expert panel Q&A webinar taking the form of your questions that you proposed registering for this webinar, centered around e-commerce and GDPR on a global scale. Thank you very much for joining us today. Joining us also is our panel. Our expert panel is comprised of Niall Tierney, who is a registered intellectual property attorney at Tierney IP. Also joining us today is Guy Pearce, who is the GDPR team lead and governance, risk, and compliance professional for Canadian GDPR Compliance. And finally, we have Robin H. Smith, who is the CEO at VL OMNI. Welcome to you all. A little bit more about our panel. Niall Tierney from Tierney IP is an intellectual property lawyer with over 20 years private practice and in-house experience gained in Ireland, Switzerland, and the United Kingdom. Niall has extensive multi-jurisdictional legal experience in the clearance, protection, enforcement, and exploitation of soft IP rights, such as brands, trademarks, logos, and designs, and also has extensive expertise in the European Union data protection law. Welcome, Niall. Also joining us today is Guy Pearce from Canadian GDPR Compliance. Guy consults in governance and risk and is the founder of Canada GDPR Compliance.ca, helping ensure appropriate GDPR compliance oversight in Canada. Welcome to you, Guy. Happy to have you with us today. And finally, we have Robin H. Smith, who is the CEO at VL OMNI, a serverless microservice-based iPaaS platform that is both elastic and scalable to the demands of scaling e-commerce and multi-channel merchants. Robin will be speaking from an implementation perspective on GDPR from a first-hand account, but also speaking on the impact of GDPR on e-commerce from our very rooted position as a data integration company. But before we get into our panel and get into our open Q&A session, I'd like to just start off with GDPR and reminding everybody why we're here today. Of course, when everybody thinks of GDPR, we think penalties, especially in North America. Interestingly enough, last week on September 20th, penalties were imposed on Equifax. If we all recall, earlier this year, Equifax had a massive data security breach. The Information Commissioner's Office has come down to fine Equifax at £500,000 over failing to protect the personal data of 146 million people, and many of those were EU citizens. So it'll be interesting to follow this story and others as it develops. But backing up a second, why does GDPR exist? And Niall, I understand that you'll speak to this a little bit more in depth in your questions coming up. But just at a high level, GDPR was driven by continental EU and the EU Charter of Fundamental Rights on protection of personal data. The European Union also sees a bit of a difference between their understanding of protection of personal data and the global perspective on the treatment and protection of personal data. In our discussions with Niall earlier this week, he actually brought up the interesting point of the European Union approaching GDPR and personal data from a human-centric standpoint versus how North America sees data and our protection and treatment of data as more of a legal requirement. So it's something that is being imposed on businesses to comply to rather than a more altruistic approach of protecting the people behind the data, which is what GDPR really seeks to do. So EU-GDPR, also known as the General Data Protection Regulation, came down into effect on the 25th of May 2018, and it is the onset of data protection rules for all companies operating in the EU, wherever they are based. We will definitely dig into what this exactly means later on. Other elements that are important to keep in mind with GDPR are, what does it govern? It regulates the processing by an individual, a company, or an organization of personal data relating to individuals in the EU. Personal data under GDPR refers specifically to any information that relates to an identified or identifiable living individual. And processing under EU GDPR refers to covering a wide range of operations performed on personal data, including by manual or automated means. So we're going to quickly get into our Q&A section here. We're going to start off with Niall Tierney on the legal considerations for GDPR, specifically what GDPR is, what the implications are, and what are the misconceptions. So our first question for you, Niall, is who regulates GDPR exactly, and how exactly is it enforced outside of the EU?
GDPR is subject to a kind of regulation from a pan-EU body. In fact, GDPR gives the responsibility for regulation to what are called supervisory authorities in each member state. So it is down to each of the supervisory authorities in each member state to make sure that bodies or entities or undertakings which process data in those particular member states are complying with GDPR. Now, Jessica, you referred to the Information Commissioner's Office investigation of the Equifax breach. The Information Commissioner is the relevant supervisory authority in the United Kingdom. Where I am based, the relevant supervisory authority is called the Data Protection Commission, and it really has its work cut out because some of you may be aware there will be a number of North American-based companies with EU headquarters in Ireland, namely Facebook, LinkedIn, Twitter. So the Irish Supervisory Authority would be the regulatory authority here, or the Data Protection Commission would be the supervisory authority here in Ireland. Now, some of you may have come across the term one-stop shop system. And essentially what this is the GDPR has set up an all-encompassing one-stop shop system. And its purpose is to make it easier for data controllers and processors in a particular member state to just have to deal with the supervisory authority in that member state. So if, let's say, we take Amazon as an example, I understand that they have their European headquarters in Luxembourg. So if a data subject made a complaint, Amazon would only have to deal with the supervisory authority in Luxembourg, and that supervisory authority would be, and it is indeed obliged to cooperate with supervisory authorities elsewhere in the European Union. So that's what we mean by a one-stop shop system. And finally, overseeing how each of the supervisory authorities are making sure that GDPR is complied with is what's called the European Data Protection Board. In effect, the European Data Protection Board is the supervisory authority for the European member state supervisory authorities.
Mm-hmm. Fantastic. Thank you for that detailed answer. And it's very interesting, the one-stop shop. Considering Amazon, I'm sure, is in that part of the world for tax purposes that are going to be caught by another law there. So that's very interesting. Thank you, Niall. Moving into our next question. Does the GDPR only affect EU citizens? And what about EU citizens living abroad? I, in my own anecdotal conversations, feel like there's a lot of confusion around these two particular questions.
Yes, and I'm not surprised. There is a lot of confusion as to who does GDPR protect, and the simple answer to that is the GDPR regulation states that it applies to the personal data of data subjects who are in the European Union. So what that means is it's not just EU citizens who are in the European Union, it is also non-EU citizens who happen to be in the European Union. Now, what does in the European Union mean? Unfortunately, GDPR does not actually define that, but I personally believe that it would have to cover non-EU citizens who happen to be resident in the European Union. I don't believe, some may disagree with me, I don't believe that it would be expected to cover, let's say, somebody who happens to be visiting Europe as a tourist. So I think you'd have to be actually resident within the European Union. Now, the question about does GDPR protect, let's say, EU citizens that happen to be living abroad? And sometimes this question does indeed come up. And the short answer is yes, GDPR does protect personal data of EU citizens living abroad, but only if their personal data is being processed by a company or a business which happens to have an establishment within the European Union. If the individual's personal data is not being processed by any company that does not have a presence within the European Union, I would hold that GDPR does not actually protect that citizen. So, for example, if you take an Irish national who emigrated to California 30 years ago, has been living there ever since, has his personal data processed by a company in California that has no presence in the European Union, GDPR will not protect that individual. That individual would have to rely on US data protection law. So yeah, it's unfortunately the GDPR regulation is a little bit I'm not going to say unclear, but basically the rule is if you are in the European Union, your data is being processed, you are protected by GDPR.
So Neil, Robin here. I have a question on establishment, because I think that this seems to be a rather nebulous kind of a thing. For a lot of people, establishment is a physical presence, and I know in the US there was just a court case around taxation. It was Wayfair against North Dakota, and they ruled that physical presence was not the litmus test anymore for this particular tax case. It was no longer the litmus test for collection of sales taxes. The notion of establishment under GDPR, how is that defined?
Well, interestingly, GDPR, it does define main establishment. And what it says is it's the place of central administration within the European Union. And that kind of ties in somewhat with how the European Court of Justice has had to consider the meaning of establishment. Indeed, this problem has actually come up in trademark law, and it was only recently that the European Union had to really consider what establishment means. But simply put, it's wherever the sort of central administration of that company is within the European Union, because clearly you will have corporations that may have establishments in a number of EU states. And what GDPR says is that you have to look at where is the central administration carried out. So where is the main headquarters? Again, looking at, for example, LinkedIn, if it has subsidiaries, let's say in France and Germany, its central administration or its European headquarters is here in Ireland. So I hope that somewhat helps, but it is a concept, or that has been the subject of a number of judicial cases before the courts in the European Union.
Okay.
Very interesting. Thank you for that. Moving on, just because we have a lot of great questions to get to, So Neil, what is a data protection impact assessment, a DPIA?
Yes, essentially, basically the GDPR deems that certain types of processing of personal data can be highly risky. And because of that, GDPR requires any data controller processor which will be processing personal data that will give rise to serious risk. And what that means is risk to the rights and freedoms of the relevant individuals or the data subjects. They have to carry out what's called this data protection impact assessment, or its acronym DPIA. So, for example, if you have a health insurance company which processes data on the health condition of members, before that company can actually start the data processing process, they have to carry out a data impact assessment to essentially highlight any risks, what would happen if, let's say, there was a data breach, that kind of thing. And also, it's important to mention that a data protection impact assessment is required if new technology is involved in collecting and processing the data. So, for example, you could have a situation where personal data is being collected by means of, let's say, fingerprint or face recognition technology. And it's very important to note that the data protection impact assessment must be carried out before the actual processing takes place. And if the DPIA actually reveals that there would be risks, the supervisory authority has to be contacted. And there has to be a certain degree of interaction with the relevant supervisory authority. So it's a very important requirement of GDPR.
Incredible. And I know that, Guy, you also had some points on DPIA to contribute to too, but I think we're having some audio issues on his end, so we'll definitely weigh in when we come around to that question in the following section there.
I think I'm back.
Perfect. There we go. It's,
goodness me, at last. Hello, everyone.
Hi, Guy. Great that you could get the audio on board there. Apologies for the technical issues. Please, I know that you have expertise around DPIA as well. Would you have anything to add to Neil's answer?
So, I think the one thing that's really interesting is that the GDPR goes into significant detail about its expectations around the DPIA. So, some of the big hype these days around data science is about scoring and profiling individuals and automatic decision making. Well, certainly, and I mean, there's certainly at least 6 or 7 or 8 other categories of requirements that are listed there. But one of the things is that if you're planning on doing any of these kinds of activities involving personal data, then certainly a DPIA is an absolute requirement. And in fact, I might want to step away from the issue of requirement and rather move it to a conversation about risk, risk identification and risk control. If you look at it as a requirement, it becomes hard and, oh man, my goodness me, I've got to do this and it's a lot of work and it's a lot of issue. It's rather a matter of, if it's about the rights and freedoms of data subjects, let's rather properly identify what those risks are and ensure that we have the right controls in place to actually manage those risks. I think what's important also is that, the GDPR does raise that you may need to raise some of these issues with your data protection officer, and we'll speak about this a little bit later. But it's important that anything, and I think Neil did mention this, anything that you identify as particularly high risk and that you potentially can't mitigate, that you must consult the Information Commission, goodness me, I've lost it now, ICO, Information Commissioner's Office, there we are, sorry, before starting the processing. And the thing is also then not to proceed with processing before you've received written confirmation from the ICO, if that's the extent of the risk that you've actually evaluated.
Wow, that's some great insight. Thank you for that. All right, pushing forward here. Adequacy notices. Neil, what are adequacy notices? This was one where it's not an easily Googleable answer.
Yes, unfortunately, it's not, and it's just I often think it's perhaps it's buried too deep in GDPR, but essentially, GDPR sets down very strict rules regarding the transfer of personal data outside of the European Union. Now, personal data can be transferred under certain circumstances. If the data is being transferred to one of the countries where the European Commission has issued what's called an adequacy decision, the transfer can take place relatively easily. Now, unfortunately, there are only, you can virtually count them on both hands, there are only a limited number of countries where the European Commission has said, look, that country has data protection laws which we deem to be adequate and perhaps equivalent to European data protection laws. Canada is one of those countries that has the benefit of an adequacy decision. Israel is another notable example, New Zealand, and actually recently Japan was granted an adequacy decision. Mm-hmm. Now, if the data is being transferred to any other country, the transfer can still take place, but there are, in a sense, stricter rules. So, for example, if you have a data transfer outside of the European Union within a group of companies, that can be done by means of what are called binding corporate rules. I'm not going to go into too much detail about those, but there are a set of rules which have to be followed in order for the transfer to take place. If outside of a group company structure, data is being transferred to a country that's not subject to one of these adequacy decisions, then you use what are called standard contractual clauses. And very helpfully, the European Commission has actually issued, and they have their own standard contractual clauses, which I would certainly recommend that if personal data is being transferred to a country that's not subject to an adequacy decision outside of the European Union, that you follow the standard contractual clauses that the Commission have drafted. You can do your own, but it's very important to note that if you're going to do your own standard contractual clauses, they have to be reviewed by the supervisory authority in the member state where you are based. So that's an important thing to take into account.
Mm-hmm. Well, no wonder why you can't Google ads off of just the internet. That's a very complex answer. And now we have one last question for you, Neil. How will GDPR affect the EU-US Privacy Shield? I think this leads really well into our previous question.
It does indeed, Jessica. Now, there was previously an adequacy decision to the benefit of the United States, and it became known as what was called safe harbor. However, that adequacy decision was actually challenged by an Austrian citizen called Max Schrems. And interestingly, he challenged the way Facebook was transferring personal data from Ireland to the United States. He made his complaint initially to the predecessor of the Irish Data Protection Commission. They refused to deal with his complaint, and they said, well, we don't have to do anything here because there's an adequacy decision that has been issued by the Commission. He challenged that. His case went all the way to the European Court of Justice, and they found in his favour. And they said that sufficient consideration had not been taken into account. And ultimately, the outcome of this was that safe harbour was invalidated. So the Commission had to go back to the drawing board. They came up with the kind of improved iteration, I suppose, for want of a better word, of Safe Harbor, and that is called Privacy Shield. So in effect, it's a kind of an adequacy decision insofar as the US is concerned. That Privacy Shield, the Privacy Shield is itself currently subject to 2 legal challenges before the Court of Justice in the European Union. Interestingly, one challenge was brought by an organisation called Digital Rights Ireland. That challenge has been dismissed because the European Court of Justice essentially said that Digital Rights Ireland did not have the standing to make the objection. The other challenge has been brought by, I guess, the French equivalent of Digital Rights Ireland, and it's likely that that challenge will also fail. So at the moment, Privacy Shield stands. So using Privacy Shield, companies can transfer data outside of the European Union to the United States. And until such time that Privacy Shield has been invalidated, or even if it is, transfers can still take place from the European Union to the United States.
Very interesting. And we'll definitely keep an eye on those challenges and post to our different social media feeds if something newsworthy does happen there. Thanks for that info. All right. So moving on into risk management, what the risk profile is for GDPR, how to assess risk at the board and C-suite levels. We have none other than Guy Pearce for Canadian GDPR Compliance, who's an expert in all things risk management for GDPR. So Guy, our first question for you is, I'm just making sure that you've got audio enabled here. What are the regulations on data security under GDPR? And Guy, are you connected with us? Perfect.
Right, thank you, Jessica. I think, first of all, it's pretty interesting to go back maybe 20 years when the term privacy by design was first coined. And interestingly enough, by none other than our own Dr. Anne Cavoukian, who served 3 terms in the Office of the Privacy Commissioner of Canada. And at that time, around about that time, you had something that was described as PETs, Privacy Enhancing Technologies. Move forward 20 odd years and you've got the GDPR, and they've used the term data protection by design and by default. And what's quite interesting is that there's a good few recitals and many more articles that go into quite considerable detail about the security requirements expected under GDPR. And these are not only for data controllers, but for data processors too. Also, I think the regulation, adopts for the first time some very specific requirements around breach notification. That it's not just, something that you loosely communicate, but that there's actually a set number of requirements that are required should you encounter a breach. Going into the regulation even further, when you go and have a look and say, all right, so what constitutes a breach? I mean, I think it would shock some people to realize that it's not just, the unlawful, hacking or malware or something that's happened to steal the millions of records that we might have referred to earlier, but it is very specific, and it even terms a breach any unauthorized disclosure of or access to personal data. Now, that's quite interesting because in many organizations, you walk inside and, folks are developing reports or performing analytics, and you have a look and you say, my goodness, there's quite a bit of personal information there. Have you conducted a privacy impact assessment? And someone would say no. And you say, all right, so how do you manage to have access to this personal data? And they said, well, I've always had access to that data. So there's plenty of problems in that statement, because whilst it's true that folks might have access to data that in today's terms of reference, might need to go through a considerable process of approval, the issue remains that effectively by having unapproved access to that personal data, that could in effect be deemed a breach because it's unauthorized. So, it goes into more depth. It speaks about pseudonymization of data, which is de-identifying data. It speaks about encryption, it goes into even more depth, and it speaks about that you need to be able to maintain the ongoing confidentiality, integrity, availability, and resilience of the respective processing systems and services. And if you're operating in a large legacy environment like a bank, just that sentence, would probably send shivers down your spine, because you've got hundreds, if not thousands, of legacy systems, many of whom, many of which have got, personal and private data on them that you don't even necessarily know is there anymore. Another requirement is, to be able to restore the availability and access. And, if there are any problems, if you've got downtime or if there's a crash or something, it's a requirement that you need to have the facility and the capabilities to be able to bring these things back up. I mean, there's many more. I mean, we could certainly probably have a whole session just around the security things. But as I said, what is really interesting is just the amount of detail that the GDPR has gone into around the whole idea of data protection by design and by default, and the specifics around breach reporting.
Agreed. I mean, the nuances of GDPR are certainly very complex. Everybody tends to assume that it has to do with, deep databases and piles of data, but it could be as simple as sharing a spreadsheet with contact names to an unauthorized third party is a breach under GDPR as well. Thank you for that detailed answer.
Jessica, if I could also just jump in and add there, the thing to bear in mind is you're not just having to consider the actual GDPR regulation itself. You're actually also having to consider the sort of follow-up legislation in each of the EU member states, which set down further requirements. For example, here in Ireland, the Data Protection Act 2018, it's 185 pages long. So, it's certainly taking into account GDPR, but also the relevant domestic legislation in each EU member state.
Yep.
Wow, that is a lot of reading. Fantastic.
Indeed.
All right, moving into our next question, just to keep moving along here. Guy, does GDPR require consent by individuals for any and all data processing?
So that's pretty much what the GDPR says. In effect, you shouldn't be processing any personal data without having achieved the consent of the data subjects affected. And so this gets really interesting because it's not only consent anymore. There's terms used such as explicit consent or free consent. It's not just about, well, they went to that web page and I managed to monitor that they went to that web page. So because they went to that web page, I think they probably consented to us using their information. It's none of that anymore unless a data subject has explicitly demonstrated a yes. And the fact is also you need to have a record of that, and we'll speak about record keeping a little later. You are pretty much not permitted to be processing any of that data. But the whole idea of consent goes a little bit further, and it speaks about what about consent for children? And we've got two issues here. The one is the age of 13, like you would have under the US's COPPA regulation. So, like if you're on Twitter or Facebook or something, as long as you're 13 and older, I think, you're perfectly okay to jump onto Facebook. But if you're younger than that you can't. Initially, the age of consent was proposed to be 16 years old.
Wow.
I think certainly Neil could certainly add to this, because I think a lot of the decision making for particular member states around that age of consent, I think, has been left up to those member states. Neil,
you're absolutely right, Guy. It is left up to member states, and it's interesting that you raised this very important aspect of GDPR because, for example, there was a significant debate here in Ireland when the Data Protection Act was being considered by the Irish Parliament. And for a while, it was thought that they were going to have the age of consent at 13. But ultimately, what came onto the statute books was that parental consent is required up to the age of 16. So it's 16 in Ireland. It'll be different in other countries. I believe it's 13 in, for example, Belgium. So each member state, yes, will have different age requirements.
Very
right.
interesting. I think Robin has a question as well.
So I've got a question here. I was thinking while I was listening to you both speak, for an e-commerce merchant, how would consent operate? Would it be I've clicked purchase on the shopping cart and I've put my credit card information and I've processed? Would that be deemed consent? Would consent be considered to have been given if I abandon my cart? You know, because there are applications in e-commerce where people will use that abandoned shopping cart information now to go out and to nurture or to try and interact with that particular customer.
So certainly I could start and Neil certainly jump in, but the answer is no. And it comes down to explicit consent. So what data is it? What are you planning to use that data for? I mean, none of those questions will have been asked, you know, just by having an abandoned shopping cart or just because you've made a purchase. So in fact, it comes down to the explicit consent that, you know, we will be using your data to do X, Y, Z, and we'll delete it after X, or we're not going to do this, or we're not going to do that, until you've seen that kind of notification and you've clicked on that little click box, which is then explicit and free. In other words, not under duress. You effectively do not have, shall I use that term or phrase, the right to be processing that personal data.
Interesting.
Completely agree. Completely agree, Guy. Again, we have to remember that consent under GDPR must be informed and it must be freely given. So to pick up on what Guy was saying, that there can't be any element of duress, or the individual who is giving consent must be aware how their data is going to be processed, and it basically comes down to informed consent.
So that's very interesting for somebody that's implementing, say, a Shopify Plus system in the UK or in Germany, where they're taking orders. If that explicit consent request is not part of the checkout process, then you potentially are in a violation of GDPR, from what I understand.
If you're going to be using that personal data, yep.
Okay.
Well, I can say from my side of things that that's a huge blind spot for e-commerce, especially in North America in relation to GDPR. Thank you for that question and those answers. All right, moving on. Guy, what is a data protection impact assessment? I know that Neil covered this off a little bit earlier in our presentation. And what must it perform? So segueing into that earlier conversation.
So I'm not going to spend too much time on this. We did start it, but really, I mean, as I said, you know, view this as a means of mitigating your own risk rather than as just another step you need to do to be in compliance. You know, and really, in effect, you know, the regulation says anything that is deemed high risk needs to have a DPIA. But from my personal point of view, you're not going to know it's high risk until you've actually performed some kind of assessment. So my recommendation, rather than something that's explicit in the regulation, is any time that you're looking at using any form of personal data, begin with a PIA or a data privacy impact assessment. Because only then are you going to know, oh my goodness, this is pretty big. You know, we might need to involve the ICO or any other supervisory authority, or hang on a minute, we're only looking at X, Y, Z, and it's relatively de-identified. Maybe the risk is a little lower, and we've got these controls in place, so we'll know if, you know, things don't go quite according to plan, you know, what we're going to do about it. But my recommendation is anytime that you're processing personal data to perform that PIA, because the main thing is that if you are ever subject to an audit, that at least you've got the records to demonstrate that you performed the due diligence on the processing that you did perform. And we'll speak a little bit more about record keeping a little later. Great,
fantastic answer. Moving right into records. What are records of processing activities, Guy? And we've got some sub-questions tied to that. Do I need to keep these records? And how does a cloud service provider contribute to maintaining records of data it processes? So maybe starting off with the first question.
So, yeah, I mean, these are all mandatory requirements. So, you know, certainly not a nice to have, oh, let's incidentally keep some records. And as I said, you know, just leading on from the previous question, if you are subject to an audit and there is a reason for an investigator to want to investigate why or how something was done, the first thing that's going to happen is, all right, so where are your records? You know, what was that risk assessment? What was the nature of processing? What was the data involved? Was a purpose defined? Was there consent? What categories of data subjects were we talking about? You know, just so many different aspects need to be covered, and it's quite explicit, really, again, about the requirements. I mean, you know, not only the controller, you know, who's the controller's representative, who's the EU representative if the controller is not established in the EU, is there a data protection officer involved? So certainly pretty much in depth, and the requirements are considerable. And I would say, again, this is not a matter of, oh, hang on, it's the regulation, I've got to keep records. This is a matter of, you know what, keep your side clean. And if there is an audit and you don't have records, you know, you're going to have a lot to account for. What is interesting, though, is that the record keeping requirement per GDPR doesn't necessarily apply to every organization. There's this little cutoff at around about 250 employees. If you've got more than 250 employees, you are obliged to keep, or you are required to keep records. If you've got less, and Neil can correct me if I'm wrong here, the regulation doesn't say you can't keep records. If I remember correctly, the term used is that the requirements for record keeping is less, not that you don't need to keep records. So again, if you've got less than 250 employees, maybe you want to think about what the important records I need to keep are. So certainly, again, it would start with that risk assessment. You know, do I have a DPIA? The next thing would be, you know, what was the data that I used? What was the purpose? Was there consent approved? Have those records in place. The last thing you want to do is fall foul of an audit and find that, first of all, even though there may not be a financial penalty, the mere fact that you may have a notice served against you has got a reputational risk. And the last thing you want to be is to be in any form of media for the wrong reasons.
Good point on that last
Absolutely.
one. Fantastic. Great. Okay, we're going to just keep pushing forward through these questions because we have a few more to carry off here. Final question for you, Guy. Does every company need a data protection officer or a DPO?
So no, so there's two parts really. So not every company needs a DPO, and again, the regulation is specific about the kinds of organizations that do need one. There's three in particular. There's public authorities. There is where the core activities of the controller or processor involve regular and systematic monitoring of data subjects on a large scale, or where the entity conducts large-scale processing on special categories of data. You know, that could be your racial, your ethnic origin, political opinion, sexual orientation, all these kinds of things. Mm-hmm. What's interesting, though, is when you get into say, okay, but hang on a minute, what does large scale mean? And the regulation isn't explicit about what large scale means. It's only when you start going back a little bit and having a look at the early drafts of the GDPR that you see that there was actually a number quoted first, and that number was, again, at least 250 employees would be, you know, subject to a requirement for a DPO. That 250 number didn't make it out into the final approved regulation. But and again, Neil will probably, you know, as a legal expert, have a better opinion on this. But I would say probably use that as a guideline. But it's certainly not something that is expressed in there. I think the big thing is, what is the purpose of a DPO? I mean, why would you bother having one? And really, I think one of the big things is that your DPO is really your point of contact between the commissioner's office and your organization. And again, the regulation puts some strict requirements for what can and can't be done about the DPO. So an organization can't just willy-nilly fire a DPO. You know, there's certain protection for a DPO within an organization. There's an expectation that the data protection officer is independent and reports to the right levels of authority in the organization. So it's not a junior role, it is a very senior role. It requires independence, and there are protections for the data protection officer. You know, so think about an organization who decides, oh my goodness, you know, we don't need all of this kind of exposure. We're going to get rid of our data protection officer because it's exposing us, and, you know, we'd rather run under the radar. Nope, there's protection offered within the regulation. And again, Neil, please chip in here. But, you know,
absolutely.
the role of the DPO within the organization.
Yes. Completely agree, Guy. And the important thing again to remember is because you might have a situation where a DPO feels that they have to involve a supervisory authority, and if they do that, the organisation that has taken on the DPO can't do anything to interrupt that. They can't be dismissed for involving the supervisory authority. So it is an extremely important role. Effectively, it's as you say, Guy, the DPO has to be independent.
It's very interesting. It's almost a legal position. I mean, it definitely does sound like a legal position, and it's interesting that that position cannot be dismissed for essentially doing their job in that role.
And in fact, yes,
Exactly.
the requirement is for someone that does understand the law, that is an expert in the law. So certainly it does make that point.
Exactly. So it's not a title to be just handed out lightly.
Dead right. Dead right.
Yeah.
Beautiful. Thank you for that answer. So we're moving into our final questions for our final panelist here, Robin Smith from VL OMNI. And we're just going to quickly overview the implementation of GDPR compliance for VL OMNI, just telling the story of what it required and what it means at a business level, but also talking about the impact of GDPR on e-commerce more broadly. So Robin, can you tell us about your journey to GDPR compliance through VL OMNI? Details like how long it took, what was involved would be extremely useful.
Yeah, thank you very much, Jessica. And this has been very interesting listening to Neil and to Guy, and putting it in context of some of the things that we have gone through at VL. We began looking at the GDPR and the impact on our business and our processing back in the middle of 2017. There was a fair amount of press that was coming out around it. And we felt from a strategic perspective that it was time to do an assessment of were we a company that was going to be impacted by this? Where were the boundaries for us? Some of those boundaries were quite clear. Others were fairly nebulous. So what we did was we engaged legal counsel both in Canada and in the EU. To be able to assess what we had in place. This resulted actually in a complete redoing and a rewriting of both our professional services agreement and our subscription agreement to become GDPR compliant. And then we went through an internal process, which was probably in parallel with the legal process was just as long and arduous. One of the first things we had to do was to figure out where we fit within GDPR, and it became quite clear that we were actually a storer and a processor of data. So we did have implications from a GDPR perspective. So we went through, as Guy outlined, a full security assessment. We looked at our logins, how we were managing that on our SaaS platform. We looked at things like encryption, the types of encryption we were using, how we were accessing data across the platform between the front end, the back end, and our portal. We also went through a whole assessment on ongoing security. How did we manage ongoing security? We also went through a full mapping of our data movement. How did we move data between the various components of our platform? And where did we receive data from, and where was it going to? And what were the implications regarding things like consent, for example? In our world, we receive data from platforms like Amazon or Shopify or bricks and mortar retail via EDI. How does all of that factor into consent? Because we are a receiver, we process it, and then we move it on to other platforms. How do they downstream handle consent? How do they handle the data, and what are the protections in place? So these were some of the things that we went through. We also implemented a process where we diagram for the customer all of our data movements, so that they have full visibility on where we're moving data from and how we're moving it and where we're moving data to. And we do this with every integration that we set up. So it's impacted our business positively, I will say. It's forced a level of discipline and accountability and documentation that we didn't have, which I think was actually a very good thing. And it's been especially positive dealing with an international audience. So
that's fantastic. Thank you for that answer. It was quite the long process. Building right into that question, as a data integrator, VL OMNI has the unique position of being embedded in e-commerce and multi-channel commerce in some interesting ways. So we have the unique ability to see how others are managing their data, and on a scale of e-commerce at large, how are you seeing the impact of GDPR, maybe North America, Europe, into Europe, because we all work in both markets as well?
Yeah, for sure. And I think it's a very interesting situation, and it's it's an interesting question. So we have customers in North America and Canada, the United States, as well as the UK. And it was the drive into the UK that really precipitated the whole wanting to dive into GDPR. There has been differing impacts. One of the things that has surprised us is the level of ignorance around GDPR, particularly in North America, and how it impacts companies that operate on a global scale. There is a heightened awareness in the EU, obviously, because it is an EU-based protocol. But I also find, even amongst the partners and the customers we work with in the EU, that there are misconceptions and there's misinformation. One of the interesting things that has come out is that in the Middle East, we're seeing a fair amount of sensitivity to GDPR. And I think that a lot of that has to do with the fact that a lot of individuals in the Gulf, in the GCC countries, actually hold dual citizenship. So there's an increased sensitivity there also. So it's been a very interesting. It's given us a very interesting perspective on people's understanding. But I would say that there's still a tremendous amount of ignorance out there.
It's very interesting that the Middle East is taking to GDPR compliance more quickly than some North American companies, to be honest. Moving into our final question for Robin here before we get into some lightning round questions just to round off our webinar. What's the role or impact of third-party data for e-commerce in relation to GDPR? We did touch on this a little bit earlier with e-commerce and shopping carts and consent around that one, but maybe we can dig into this as a panel.
Well, I think just to round out, for us, when we mapped out where data was coming from and where we were moving it to, because we are a point-to-multi-point solution, we may receive, for example, data from a Shopify Plus site that's related to an EU individual. So that individual goes on, places an order. The payload, if I can get technical, the payload includes personally identifiable information to a living individual. So we need to make sure, A, that that's encrypted. But consent has been a nebulous issue. How we process, store, and move that data now becomes a bigger issue, because if you think of a transaction, we move that data down into an accounting system, but we could very well be moving that into a marketing automation platform that the customer is using, where they are now being nurtured, they're receiving newsletters, they're receiving emails. And so one of the issues for us has been, how does consent flow down from the original source, say from a Shopify store, through us down to that marketing automation platform? And obviously there are the opt-out mechanisms on the marketing automation platform. But is the customer even consenting to that? And is the company that is the brand that is selling out on the internet, are they even aware that they need to get that consent? So these are some of the issues that we've run into, and raising that subject with our partners has been a difficult matter at best, because a lot of people, again, don't feel that either GDPR applies to them, or don't have a full understanding of the implications of it.
I agree. Thank you for those answers, Robin. We're going to move very quickly since we're coming to the top of the hour, and this has been a fantastic webinar. Thank you to you three panelists again for your contribution. Definitely didn't want to cut off the discussion, but just opening up for some couple of broader questions to the panel. When have you seen the benefits of GDPR compliance? And if you have a specific example, we'd love to hear about it. Now, Neil, do you want to start off?
Yes, I'm not so sure if this might be a kind of a benefit, but there have been a number of recent cases where you could see the positive impact of GDPR. For example, British Airways had an unfortunate hacker situation where their customer data was hacked. Now, they handled it very well. They fully complied with GDPR. They notified the UK Information Commissioner well within the required term, or 72 hours, and also they notified the individuals involved. And I can tell you I was one of those, because I got an email from British Airways to explain what had happened. So clearly, that shows that GDPR is working. There are organizations in the European Union that fully understand and comply with their obligations under GDPR. So that's where I see the benefit of it.
Yeah, fantastic. It's not all about the penalties at the end of the day. Robin?
Yeah,
exactly.
I would also add to that, Neil, I think your example is a very good one. We've certainly seen amongst our customers a heightened awareness around security and protection of information, which prior to this, I would, if I compare a year ago to now, a lot of companies paid lip service to it. I think a lot of companies now are much more in tune to how are they going about protecting the information. Those that are publicly traded, yeah, it's a much bigger issue. But I also find even amongst some of the SMBs that we deal with, they are concerned about it.
Yeah, and it's interesting because GDPR does force you to do all this documentation, risk mitigation, and so forth. So it's not something that, as you said, Robin, you can just provide lip service to, oh yeah, we're compliant. No, you actually need to show the results of that compliance.
Correct.
And have the documentation. Correct. Okay, moving into the last question here. Just a general one. I wanted everybody's opinion. So who's better informed on GDPR in your opinions? Is it the businesses or is it the consumers?
If I could jump in with an answer straight away on that, Jessica, I have to say in the European Union, traditionally it's been consumers, because you have to remember Max Schrems was a consumer, and he was very aware of his rights under the existing data protection regime before GDPR came in. So that goes to show you that particularly in many continental European countries, Germany being perhaps a very good example, consumers are quite aware of their rights under GDPR. Businesses are getting there, I think, because they have to, because they are going to be impacted if there's a breach of GDPR. But certainly in the European Union, it is consumers.
Mm-hmm. Robin or Guy, would you agree from the North American perspective?
Guy? I will let
Robin,
you go first, Guy. Yeah, no, I think from my perspective and what I've seen in North America, I would put it at roughly 50-50. You have educated consumers who are fully aware of their privacy rights. Particularly in Canada, I find in the US, a lot of people don't really care. And that speaks back to that difference that we highlighted right at the beginning. But I also find businesses now are starting to pay attention. So I would actually put it at about 50-50.
That's interesting. And Guy, if you want to chime in, please do. Otherwise, we're going to keep moving on here. We'll skip our final thoughts there. Just rounding it off today, I wanted to thank everybody, especially our 3 panelists, for participating in this panel. It was definitely illuminating, and we will be making this available for viewing on the web afterwards, because I believe, and I believe we all believe, that this is an important conversation. GDPR is definitely not over. It's just beginning, and people need to make sure that they're protecting their businesses, but also that personal data and the people behind it as well. So for all of our webinar attendees, please do get in touch with us if you have further questions. We've got everybody's social media, their Twitter accounts up there, and of course websites as well. If you'd like to join the conversation, we do have a hashtag for this webinar, GDPR Reality Check, down in each bottom right corner of the slides. We'd definitely love to continue this conversation online and off. So thank you again, everybody. This has been GDPR Reality Check, how will regulations impact my e-commerce business? Thank you all for attending, and we will see you all next time. Thank you, Guy and Neil, and thank you, Robin.
Thank you.
My pleasure.